Hello everyone, this is your instructor in Business Laws and Regulations. Still, our topic for today is General Provisions of Partnership. In this video, I'm going to discuss the third part of the General Provisions. Let's start with the kinds of partnership. So there are kinds of partnership as to object. There are also kinds of partnership as to liability. There are also kinds of partnership as to duration. And there are also kinds of partnership as to representation to others. So, unahin natin yung kinds of partnership as to object. There are two kinds of partnership as to object. The first kind is called universal partnership, and the second kind is called the particular partnership. Yung universal partnership, may dalawang klase din yan. Yung una ay tinatawag na universal partnership of all present property, at yung pangalawa ay tinatawag na universal partnership of profits. Mamaya, i-discuss ko yung particular partnership. But for now, mag-focus muna tayo dito sa dalawang klase ng universal partnership. Yung universal partnership of all present property at yung universal partnership of profits. Let's start with the universal partnership of all present property. When we say universal partnership of all present property, this is a partnership in which all the partners contribute all the property which actually belong to them to the common fund with the intention of dividing the same among themselves as well as the profits which they acquire therewith. Meaning to say, kaya tinawag na universal partnership of all present property kasi i-contribute ng partners yung lahat ng kanilang present property. So, ganon lang kasimple yung explanation sa universal partnership of all present property. So, what are those properties that shall belong to the common fund of the partnership? First, property belonging to the partners at the time of the constitution of the partnership. In short, yan yung present property. So, lahat ng present property ng lahat ng partners ay mapupunta sa common fund ng partnership. At the time of the constitution of the partnership, ang ibig sabihin niyan ay at the time of the establishment of the partnership. So, lahat ng property na meron ang partners at the time of establishment of the partnership, magiging common fund ng partnership. For example, may truck yung isang partner at the time of the establishment of the partnership. So, magiging common fund ng partnership yung truck. Another example, may lote yung partner at the time of the establishment of the partnership. Then, yung lote, magiging common fund din ng partnership. Next, profits that may be acquired from the present property. For example, at the time of establishment of partnership, may truck yung partner. So, yung truck na yon magiging common fund ng partnership kasi nga present property siya. Yung truck na yon pinaparenta. Of course, kapag pinaparenta yung truck, may profit na madederive doon. Yung profit na madederive sa pagpaparenta ng truck ay magiging common fund ng partnership. Yan yung sinasabing profits that may be acquired from the present property. Next, property acquired by each partner after the formation of the partnership, but only if stipulated. In short, yung property na tinutukoy dito ay yung future property. Take note na itong property acquired by each partner after the formation of the partnership ay magiging common fund lang kapag pinag-usapan ng lahat ng partners na included siya sa common fund. Pero kapag walang stipulation o wala silang pinag-usapan, nakasali sa common fund yung property acquired by each partner after the formation of the partnership, then hindi yon kasali sa common fund. For example, bumili yung isang partner ng van after the formation of the partnership. Yung van ay hindi kasali sa common fund ng partnership. Why? Kasi wala namang pinag-usapan yung mga partners na kasali sa common fund yung property na na-acquire ng partners after the formation of the partnership. Pero kapag pinag-usapan nila na kasali yung property acquired by partners after the formation of the partnership, then kasali yung van sa common fund ng partnership. This property shall include first, the property itself, except that the stipulation shall not include property acquired by inheritance, legacy, or donation. Anong ibig sabihin nito? Ang ibig sabihin nito, hindi pwedeng pag-usapan ng partners na pwedeng kasama sa common fund ng partnership yung property acquired by inheritance, legacy, or donation after the formation of the partnership. So yung property acquired by inheritance, legacy, or donation after the formation of the partnership ay exclusive property ng partners yan. However, the profits and fruits therefrom, including those from property acquired by inheritance, legacy, or donation, ay kasali sa common fund ng partnership only if there is stipulation, kapag merong pinag-usapan ang mga partners. Pero kapag wala silang pinag-usapan, then yung profits and fruits from the property acquired by inheritance, legacy, or donation ay exclusive property ng partners at hindi kasama sa common fund ng partnership. Next, universal partnership of profits. When we say universal partnership of profits, this comprises all that the partners may acquire by their work or industry during the existence of the partnership. So what are the profits or property which shall belong to the partnership? First, profits obtained by the partners by their work or industry during the existence of the partnership. Meaning to say, yung profit na makukuha ng partners during the existence of the partnership, mapupunta yon sa common fund ng partnership, pero dapat pinagtrabahuan nila yon. Nag-exert sila ng physical or intellectual efforts. Accordingly, profits acquired by the partners without the exertion of physical or intellectual efforts, such as those acquired by chance or lucrative title, are excluded. In other words, yung profits na na-obtain ng partners nang hindi sila nag-exert ng physical or intellectual efforts ay hindi kasali sa common fund. So, exclusive property yon ng partners. For example, nanalo ng loto yung isang partner. That is a profit without exertion of physical or intellectual efforts. That is a profit acquired by chance. Therefore, hindi yon kasama sa common fund ng partnership. Next, the usufruct or the use of the property belonging to each partner at the time of the constitution of the partnership. Take note na yung ownership of property ay nasa partner pa rin. That is an exclusive property of the partners. Yung mapupunta lang sa partnership ay yung usufruct or paggamit doon sa property. Next, the profits and fruits from the properties aforementioned, meaning to say, yung items A and B. Next, profits and fruits, if stipulated, of property acquired by each partner after the constitution of the partnership. So, yung profits and fruits na makukuha ng partners sa property nila after the establishment of the partnership ay magiging common fund ng partnership kapag meron silang stipulation or meron silang pinag-usapan. If there is no stipulation, then hindi yan mapupunta sa partnership. That is universal partnership of profits. Next, rule in case universal partnership is without any specification. Articles of universal partnership entered into without a specification of its nature only constitute a universal partnership of profits. So, gumawa yung partners ng articles of partnership. Ang nakalagay lang doon ay articles of universal partnership. Pero hindi in-specify if it is a universal partnership of all present property or a universal partnership of profits. In this case, ang sabi sa batas, yung partnership ay universal partnership of profits. So, bakit universal partnership of profits? This is because a universal partnership of profits transmits less rights and interests. Sa universal partnership of all present property kasi, since lahat ng present property ng partners ay kasama sa common fund ng partnership, mas madaming rights and interests ang matratransmit sa partnership. That's why ang assumption ay universal partnership of profits. Let's now proceed to prohibition to enter into a universal partnership. There are specific persons who are not allowed to form a universal partnership. Those who are prohibited from making a donation to each other are also not allowed to form a universal partnership. So that includes the husband and wife under Article 133 of the Family Code. Those who are guilty of adultery and concubinage. Adultery is a crime committed by the wife kapag nangaliwa siya. Ang concubinage naman is a crime committed by the husband kapag nangaliwa siya. This is under Article 739 of the Civil Code. Kasama din dyan yung persons who are guilty of the same criminal offense, meaning to say, yung adultery and concubinage, if the partnership was entered into in consideration of the adultery and concubinage. Ngayon, bakit sila bawal mag-form ng universal partnership? Because a universal partnership is essentially a donation. Kaya if they are prohibited from donating to each other, then they cannot do indirectly what the law prohibits directly. Kasi kung papayagan mo silang mag-form ng universal partnership, then mukha din silang nag-donate sa isa't isa. That's why pinagbabawalan din yung mga yan to form a universal partnership. Next, let's proceed to the second kind of partnership as to object, and that is a particular partnership. Ang ibig sabihin nito, hindi lahat ng property ng partners ay involved, at tatlo ito. Yung una, the object is either determinate things or only their use or the fruits. Or it can be for a specific undertaking or for the exercise of a profession or occupation. For example, a real estate partnership whereby partner X contributed a parcel of land and partner Y a building. Another example, a real estate lessor whereby X contributed cash and Y the use and lease of his building. Another example, a partnership formed for the exercise of the law profession. So kung mapapansin nyo, yung general professional partnership or a partnership formed for the exercise of common profession, yon ay particular partnership. Ang tanong, may a husband and wife form or be partners in a general professional partnership? The answer is yes. Since a general professional partnership is only a particular partnership for the exercise of a common profession or occupation. Ang bawal lang naman sa husband at wife is to form a universal partnership. Doon lang sila prohibited. Kaya pwede silang mag-form ng general professional partnership. Next, kinds of partnership as to liability. So there are also different kinds of partnership as to liability. So it can either be a general partnership or a limited partnership. When we say general partnership, this is a partnership where all the partners are general partners who are liable to the extent of their separate property after the partnership assets have been exhausted. So lahat ng partners sa general partnership ay general partners na kung saan yung general partners ay liable up to their separate property kapag exhausted na yung assets na pambayad sa liability ng partnership. Ang ibang tawag sa liability ng general partners ay unlimited liability. On the other hand, when we say limited partnership, this is a partnership where there is at least one general partner and at least one limited partner. Yung liability ng general partners ay up to their separate property, while yung liability ng limited partners ay up to their capital contribution. Ang ibang tawag sa liability ng general partners ay unlimited liability. At ang ibang tawag doon sa liability ng limited partner ay limited liability. So kailangan na merong at least one general partner to protect the third persons. Of course, para mabayaran yung utang ng partnership sa kanila after the partnership assets have been exhausted. Kasi kung lahat ng partners ay limited partners, hindi na mababayaran yung third persons kung exhausted na yung assets na pambayad sa liabilities ng partnership. Kasi nga, ang liability ng limited partners ay limited lang sa kanyang capital contribution. Kaya, sa limited partnership, dapat merong at least one general partner to protect the third persons. Hindi pwede na lahat ng partners ay limited partners. Dapat merong at least one general partner and at least one limited partner. Next, kinds of partnership as to duration. So we also classify a partnership as to the duration of the partnership. So it can be a partnership for a fixed term, a partnership for a particular undertaking, or a partnership at will. When we say partnership for a fixed term, this is a partnership for which a period for its duration is fixed by the partners. In other words, may sinet na term yung partners kung kailan madidissolve yung partnership. For example, a partnership with a term of 3 years. So after 3 years, dissolve na yung partnership. Kapag sinabi namang partnership for a particular undertaking, this is a partnership which is organized for a certain undertaking which when attained will cause the termination of the partnership. As the name suggests, partnership for a particular undertaking, pag natapos na yung particular undertaking, then the partnership will be dissolved. For example, partnership formed to construct 15 residential houses. So after makonstruct yung 15 residential houses, dissolve na yung partnership. Next, when we say partnership at will, this is a partnership where no period is fixed by the parties for its duration. Hence, may be terminated at will by the partners. Meaning to say, the partnership at will exists based on the will of the partners. Kapag ayaw na nila, they can validly dissolve the partnership and not be liable for damages. If a partnership for a fixed term or particular undertaking is continued after the expiration of the said term or the attainment of the said undertaking without any express agreement, the partnership becomes a partnership at will. Diba, sa partnership for a fixed term at partnership for a particular undertaking, pagdating ng fixed term, or kapag natapos na yung particular undertaking, then the partnership will be dissolved. Pero allowed naman ang partners na i-continue pa rin yung partnership even after the expiration of the term or the fulfillment of the undertaking, in which case they will be governed by the rules concerning partnership at will. Or ititreat na yung partnership as a partnership at will. Yun yung ibig sabihin ng law or rule na ito. If a partnership for a fixed term or particular undertaking is continued after the expiration of the said term or the attainment of the said undertaking without any express agreement, the partnership becomes a partnership at will. Next, kinds of partners as to representation to others. So we also classify a partnership as to representation to others. So it can be an ordinary partnership or partnership by estoppel or estoppel. When we say ordinary partnership, this is a partnership which actually exists among the partners as well as to third persons. Meaning to say, this is an actual partnership since para sa mga partners at para sa mga third persons, itong partnership na to ay nag-e-exist. In an ordinary partnership, of course, this is composed of actual partners who are also partners as to third persons. On the other hand, kapag sinabing partnership by estoppel or estoppel, this is one which in reality is not a partnership but is considered as one with respect to those who by reason of their conduct or admission are precluded from denying its existence. Meaning to say, this is not an actual partnership, but for those who misrepresent themselves as a partner in a partnership and those who consented to such misrepresentation, it's as if there is a partnership. Yan yung sinasabing partnership by estoppel or estoppel. Dito sa partnership by estoppel or estoppel, meron kasing tao na nirepresent niya ang kanyang sarili na partner sa isang partnership. That is a misrepresentation since hindi naman talaga siya partner dun sa partnership. May mga actual partners na magbibigay ng kanilang consent to such misrepresentation. Pwedeng lahat ng actual partners o hindi lahat ng actual partners ang magbibigay ng kanilang consent. Ngayon, may mabubuong partnership by estoppel or estoppel doon sa taong gumawa ng misrepresentation at doon sa mga actual partners na nagbigay ng kanilang consent to such misrepresentation. Yan yung ibig sabihin ng partnership by estoppel or estoppel.